Ms. Houston, just so that we're clear on the record, this was the show cause hearing originally set by the court regarding your failure to appear for Mr. Slater's preliminary examination. I further indicated to you that it was troublesome for the court that this got sat, and that at the time that it was sat, court is aware that you knew that you had taken employment elsewhere, and that Mr. Slater then appeared for a preliminary examination, in effect with not, I won't say without counsel, but without counsel that was ready to proceed regarding his statutory right to have that hearing. Further, that ultimately the court was also informed, at least by Mr. Slater, that he had not been communicated with by you except for the initial time, had not been communicated about your impending departure when he then appeared before the court. Since that time, I will also indicate to you that because of this, and I'm only dealing with the Slater matter, but there were other instances during the same time, one being in 15th District Court, and I believe one being downtown before the Circuit Court, where you were counsel of record and did not appear for those proceedings. I will say also specifically regarding this proceeding that on the date and time set for the preliminary examination, that this court, through my office, tried to contact you numerous different ways, and we did not receive a response. The ultimate thing in that is that Mr. Slater's preliminary examination, which I believe was ultimately waived, but he did not have his preliminary examination, and his proceeding was delayed by, I believe, approximately 2 weeks. So the court has issued the show cause to see why the court should not hold you in contempt and issue sanctions.
So, Your Honor, I did inform like the people that assigned me the case, I did inform them and I let them know what case I had outstanding. I was then contacted by the attorney that would be subbing in for me, and I gave him all of the information. I sent it to an email as soon as he contacted me. It was almost simultaneous. So,
but what day was that?
The day it was, so they contacted me, the sub attorney, they contacted me on March 8th, and I sent it on March 8th. Substitution attorney was Bernstein.
Yes.
And I sent him all of the discovery, everything that I had on Slater.
And
beforehand, I went to the special counsel office and I just gave them a list of everything that I had outstanding.
But counsel, that your obligations under the court rule are to still appear. I mean, because the preliminary examination said that was on the March 8th. That was a Friday. Preliminary examination was set that Tuesday for Mr. Slater. And Mr. Slater had not been informed when you were doing all of this.
And then I spoke with his mother, and I informed her, and then I gave her the new attorney's information with Mr. Slater's mother.
Why would on February 29th, you have set this for preliminary examination when you knew that you would not be counsel, that you had accepted other employment?
I thought that another counsel would sub in for me sometime. Because like I said, I informed special counsel who assigns this. I informed them, so I thought that another
On what
attorney.
day did you inform them?
This was February 22nd, I believe. February 22nd, I believe.
Then why do I not receive a motion to withdraw until March 11th?
I don't know, Your Honor.
Well, you're the one, counsel, you can't just say I don't know because you're the one responsible to withdraw from the case. Regardless of the fact that the MAC office is the one that gives your name, it is your obligation. It's not their obligation. You would agree with that. I mean, you're the attorney of record.
Understandable.
But if you knew on the 22nd of February that you were going to be withdrawing from cases, I don't, on this matter, I don't get anything until March.
My apologies. I didn't know. Like they said, they did all the motions to withdraw for me, so I thought they would have got it sooner. I did inform them February 22nd, and I thought that substitution counsel would be in before then.
Ms. Hughes, if that's true, then why on February 29th, this would have been a week after, do you appear and set the case for preliminary examination?
Because I thought,
and not inform the court, not inform the defendant, not inform anybody that you won't be counsel of record?
again, I thought that it would be substitution counsel. So I really thought that it would be a counsel would be substituted in, and that
doesn't even make any sense, Ms. Hughes. If on the 22nd of February, you know, and you say you informed them of that, you appear on the 29th of February, do not do anything to withdraw, do not do anything to place your client in a position where they're not worse off. You indeed, what you do is you set him for preliminary examination at a time you know you're not going to be counsel. So that doesn't even make what you're telling me doesn't make any sense. So why didn't you do something on the 29th?
Okay, I was still trying to get all of my other ones in order, not just this court, but just all of the other courts that I was trying to tie up those, and ball got dropped.
It doesn't make any sense to me, Ms. Hughes. And I want to give you the benefit of the doubt on this, but if you're telling me on the 22nd of February that you knew that you had other employment, that you informed, you're saying at that time, without turning this into a full-blown hearing, but I'll bring them down, that on the 22nd, that you informed the MAC office. You appeared then on Mr. Slater's case on the 29th, set it for a preliminary examination, say nothing to the court, nothing to Mr. Slater or anyone that you will not be the one handling the preliminary examination. You are still the attorney of record. The 12th comes along because that's the date it got set for. For March 12th, you do not appear on March 12th. We sent you various communications during that day. You didn't appear before the court on the 12th and just did nothing. In fact, counsel, you don't know on the 12th that other counsel has been appointed to represent him.
I did know on the 12th. I sent the other counsel the info on the A. So it was my understanding that was his other counsel. If he communicated to me and asked me for the discovery,
you are not released from an obligation until the court releases you. You do know that, don't you?
yes, and I thought that with him calling me and informing me that I was released. My apologies, the ball got dropped.
The ball didn't get dropped. I don't have an order even to sign if I wanted to. But I don't even get an order to me that I eventually signed until, which is your obligation to withdraw, not the MAC office obligation to withdraw. I don't get an order until the 12th, the date of his prelim. And then they have to adjourn the proceeding out. Anything else you want to say?
No.
And Ms. Hughes, I'm just going to let you know, I don't appreciate also that when my staff reaches out to you, when this court reaches out to you, irrespective of anybody else, we got no response from you. None. We sent emails, we made phone calls.
I didn't get a phone call.
We did not get a response. Anything else you want to pay? I was trying to find a way where this was not something that I should sanction misuse, but I don't see that. Anything else you want to say?
Nothing further.
I'm going to sanction you to $500. That's to be paid to the court. When can you get that paid to the court?
In about 2 months.
Pardon?
I'm going to need about 2 months. Is that something I can pay online or?
You'll have to ask the clerks up front. That's to be paid by June 21st, 2024.